You know, political rookies or greenhorns or new boys can tell that of all political engagements, political interest is like good wine. You sip it with relish. You know, the Red Chamber of the National Assembly, that's the Senate, is heading to the appeal court on account of the court order directing the Attorney General of the Federation to delete Section 8412 of the newly signed Electoral Act. Recall also that a federal high court sitting at Umuahia, Abia State, presided over by Justice Evelyn Anyadike, ruled on March 18 that the rancorous Section 8412 be expunged from the Electoral Act. Remember also that the opposition People's Democratic Party, in an ex parte motion, sought an order restraining the president, the AGF, and the Senate president from tampering with the document. Jide, in politics, the key phrase or word is interest, nothing more.
Yes, but equity is also important.
Equity and interest.
Yes, equity is important. If you want us to go onto the field for a contest, make that field a level playing field. Be fair to everyone. Do not allow anyone to have an advantage over others. If you are better than me, you clinch the diadem. But it's not for someone to already be in an advantage position ahead of the contest. And the rules should not be tampered with to favor an individual. If you do that, then there's no fairness, there's no justice. So, in this case, the National Assembly that authored the Electoral Act was supposed to have been joined in that suit. They didn't join them, they didn't join INEC, we just saw judgment.
Was that deliberate, or do you think?
Well, some of the people that I spoke with, I can't imagine that people will do that in this modern age. But some of the people that I spoke with said it must have been deliberate. Because you ask yourself, when did the hearing take place? And within so short a time, we got judgment. Within so short a time, the Attorney General was already thinking of deleting. Whereas he has no power to delete any portion of our law. The power resides in the National Assembly.
Okay, because they also make laws.
Yeah, they are the lawmakers themselves. Yeah. If they don't want any portion of the law, they can decide to do away with it and come up with a new one. But it's not within the powers of the Attorney General to go and expunge any portion of our law. But that was what the judge told the Attorney General to do. So why would you not join these people so that they can defend themselves? The upper courts of records are going to take that into cognizance, that did these guys get fair hearing? And if they didn't get fair hearing, we may eventually see what looked like what happened to Justice Okonaban the other day when at the appeal court, the judge tongue-lashed him thoroughly and said what he did, even a lawyer in training wouldn't have done, because you know what the law says. So the contentious issue is public officers,
public people,
political office holders.
Yeah.
As far as the Constitution is concerned, the people in Section 318, the people that the judgment imagined to be public office holders are not political office holders.
There are two different.
In the contemplation of the Constitution, those guys, those political appointees, are not reckoned with as public office holders.
A matter of definition here.
Yes. So, but if we now give a judgment, imagining that those guys they are public servants, their rights have been abridged by this law, then you have to actually show how. Then who was the person that took them the National Assembly to court?
Yeah.
Is he one of those people
joined in the suit?
No. Is he one of those people who believe that his right had been breached? If he's not one of them, because I can't get up from here now and go and sue the National Assembly over that matter, that kind of matter. The court will see me as an interloper, a meddlesome interloper. So these are some of the issues we are not.
So when the president raised eyebrows regarding this same section, what do you think? What was going through his mind?
He was trying to help his aides, people like the Attorney General and the rest of them. It is not something hidden that they have political ambitions. He thought that that would not favor some of his aides. So he was doing that to favor his aides.
Was doing it in good faith.
Who can define
political?
It's
good
not
faith.
in my place to define good faith as far as this matter is concerned. You know?
Adequately, in politics, let me quote Judge Bernard Shaw. He said, democracy is a device that ensures we shall be governed no better than we deserve. So who went to court? You think this was not designed to be that way? Because I hear that in politics, if anything goes wrong, just know it was designed to go wrong that way.
Yes, I know it was designed. Let me be very frank with you. The day the president signed that Electoral Act and got the promise of the National Assembly to amend the aspect he didn't like, I was smiling that that would not happen. And many of my colleagues in the newsroom said, no, they will do it. I said they will not do it.
That is the National Assembly people.
Yes, that the National Assembly will
touch
not.
it.
I said they will not do it. That the process of enacting a law is not as simple as some people thought. That instead of you to take care of whatever you wanted to take care before you signed, the moment you signed it, that's the law of Nigeria. And if you now are now hanging on the promise that that will be done, the president of the Senate, the Speaker of the of the House of Reps, is not the National Assembly. The members have various political parties and they represent various interests. And before you get it done, the President of the Senate, the House of Reps Speaker, they will have to work very hard to galvanize their colleagues. Yeah. In this instance, it may be difficult. I said I don't foresee them obliging the president, And when it happened, I said, didn't I say so? Now, going back to the issues, who went to the court? I mean, who
really approached the court?
On the normal thing, why would you want to do a law that would be unfair to anybody? These are, whether you call them public office holders, political office holders, these are Nigerians. And under the Constitution, all of us have rights. You get my point? You are members of the National Assembly today. Tomorrow, you may be a minister. Tomorrow, you may be this and all that. So, why the intrigues is unnecessary as far as I'm concerned. But in this matter, it has even gone to the level of being a little bit complicated because the time is no longer there for anybody to do anything except the court, does otherwise. That's the law of Nigeria. But those who are in government today, and I'm being very, very honest, very wealthy, very, very powerful, this is the reaction from them.
Okay.
This is the reaction from them. And as you move, it's going to get dirtier.
All right. Yusuf, let's go to the National Assembly now, the Senate specifically. Joining us via Zoom would be the spokesman of the Senate, who is also a doctor of law, Senator Ajibola Bashiru. Distinguished, good evening. All right. Okay.
It's nice hanging out with journalists.
Okay.
I greet you. Welcome.
Good afternoon.
Thank you very much.
Okay, so paint a clearer picture for us regarding this matter.
Why have you chosen to appeal?
Why are you appealing the court judgment?
Yes, first and foremost, the interpretation placed upon Section 8412 and the declarative beliefs given by the Federal High Court in Umuahia, it is felt that it does not actually represent the authoritative position of the law. First and foremost, Section 8412, for the purpose of educating Nigerians, has two aspects. One, it provided for the fact that political appointee should not be voting delegates at convention, congresses for the purpose of nominating candidates for election. That certainly cannot be a matter for whether somebody is qualified to vote or be voted for. It is just saying that attending to a mischief that we have known of executive arm appointing people for the purpose of creating automatic delegates in favor of such people, which we think will not augur well for democracy and for democracy in the country. So first and foremost, the whole story of Section 8412 is not about whether political appointee ought to resign before they can contest for election. It also precludes them from being under the cloak of just being an appointee voting delegates for the purpose of emergence of candidate at election. So certainly that cannot be an issue of qualification, and therefore the judgment in that regard cannot cover that aspect of Section 8412. On the other aspect, that precludes political appointee from being voted for at a congress or convention for nomination of candidates, is certainly not within the scope of existing provision of the Constitution. We take the point, subsection 3 of Section 1 of the 1999 Constitution state that any law inconsistent with the provision of the Constitution will be declared null and void to the extent of that inconsistency. In the case of Musa and INEC, the Supreme Court has extended it to say that even if a provision is similar, identical with what is in the provision of the Constitution, to the extent of repeating what the Constitution provides for, it will be inconsistent and therefore be declared null and void. The question that we need to ask is this: are there provisions in the Constitution that cover political appointee in terms of their qualification for participating at the primary? First and foremost, all the sections referred to as the basis of the decision of the Federal Court in Umuahia only refer to persons employed in the public service of the state or the federation. Yes. The phrase or the clause, persons employed in the public service, is defined under Section 318 of the Constitution and has been given judicial interpretation in cases like Dada and Adiyeye. And what is interpretation? They said it's only people who are employed in the public service. A political appointee is not a person so employed in the public service. Similarly, a person elected to the office of the chairman, National Assembly, is also not covered by that provision. So it is only those people who can be said to be employed in the public service that are covered by the existing constitutional provision. And that provision only also relates to participation at the general election. What Section 8412 has done is to provide for political appointee, which is not part of what has been covered by the Constitution, and also as a minimum requirement of participating at the nominating congress or convention. And there's no date specified. So I don't know where people talk about 30 days. It only precises that you cannot participate, you cannot vote, you cannot be voted for at a convention when you are still a political appointee. It may mean that you may resign a week or a few days before the Congress or the convention. So the contention here is that could it be said that a provision that has nothing to do with the extant provision of the Constitution could be said to be null and void? But the more interesting aspect which occupy the National Assembly, particularly the Senate, is that order asking that a provision of the law should be deleted from the written law. It is established position of the law that when an act or a provision of an act declared to be unconstitutional, what the court will do is to apply what is known in law as blue pencil rule, by which to say that this provision has been declared null and void. It is not to the extent of saying Attorney General should go and delete on his own a law already by the National Assembly and assented to by the President. It is a strange order that it is felt that there is a need to test the law in that regard. With respect to the court that made that decision, with adversarial system of adjudication in Nigeria, a case may be as good or as bad as representation by the two sides. But when you look at the judgment of the court, 5 pages of that judgment contain arguments deployed by the Attorney General's office to defendant in support of the case presented by the plaintiff. So in this regard, could it have been said that there have been fair presentation of the case for and against the constitutionality-wise of 412 before the federal court? The answer on reading that judgment is that it's no. The honorable judge in that case was thought to have failed of qualitative and sound argument for and against the decision to be taken in that regard. And it is felt by the Senate that it will be that we need to test the law and ensure an authoritative pronouncement court in regard to the issues regard.
Thank you, distinguished. This our job is, it is time bound. It's time to go for some commercials. Just wait there, we'll back to you after the commercial break. All right, please stay with us. We'll be back shortly. All right then, welcome back. We were, just before the break, we were having a chat with Senator Ajibola Bashiru, spokesman of the Red Chamber of the National Assembly, that is the Senate. Distinguished, we are back with you. Are you there?
Yeah, thank you very much. I'm here.
Okay. It's only natural to ask at this point, did you know about the court case at Umuahia? Did the Senate know about it?
Before the judgment.
Before the judgment.
We were not, we did not know about the judgments. We were not served. And I must tell you that there are so many things appear to be wrong about the case itself. One is marks of forum shopping. Then he also smacks of whether indeed the Attorney General, with respect to him, is not allowing his personal interests to conflict with the oath of his office. And I say it with all sense of responsibility of somebody who has served in the office of Attorney General at my state. When you read the judgment, it seems to you that it is not really a contested case. It is really a considered case. I believe that irrespective of personal opinion of an Attorney General, when a government is sued and the law is being challenged, all available arguments ought to be canvassed to avail the judge to come to a determination. I'm equally worried about the speed by which the Attorney General on the same Friday came up through his media aid to say that he's going to abide by the judgment of the court. Yes, there's nothing wrong in abiding by the judgment of the court, but I raised a poster. I hope subsequently the Attorney General will be willing and ready not to contest on appeal any judgment given by court of first instance in Nigeria. Oh. And whether it will also not be okay for him to withdraw all the appellate cases that he has so filed against all other cases of first instance. Then, in view of the fact that the matter is a fundamental issue of constitutional importance, is it not better to avail parties possible interested party of opportunity of appealing that decisions in order to be able to have an authoritative pronouncement of that. My opinion is that for us in the APC, we need to tread carefully because the army of political appointees that may contest election may find out well when this law is tested by, in other cases, that the reliance on the high court decisions may not ultimately avail them, because looking at the constitutional provisions and the clear distinction between political appointee and person in employment of public service, the decision may not stand the test of time, and a legal hiatus might have been created for my political party in feeding people who chose to not to comply with the provision of 8412 on the strength of the case. I'm also equally aware of a case filed by the PDP in Abuja, which is seeking to validate that decision, which is still pending. Assuming that decision now succeed, then what happened with the hastiness that Honorable Attorney General appear to be given to implementing, so to say, the decision to delete the provision of 8412 from the Gazette of the Federal Republic of Nigeria.
All right, distinguished, if you lose the appeal, would you be going to the apex court?
Of course, it is good. We don't have, if you load the body language and the attitude of the Ninth Army Senate, we are not in ego contest with anybody. We are open to test the law and see whether what we have done is in line with the law of the land. And if the ultimate court decide that what you have done is not in line with the Constitution, we take it in good faith. We don't have any personal interest beyond the fact that we feel that a level playing field should be created for all people in electoral contest, and people should not use the wherewithal of political appointment to not concentrate on issue that they have been given appointment and face politics. So that those are the mischief that we intend to cure. And the other mischief is also that we don't want an overload of political appointee to interfere with democratic processes of emergence of candidates in our political parties. But if the Supreme Court thought otherwise, then we don't have any personal thing to lose, but to say that we have been able to pursue the position of the law to its logical conclusion.
There is something that I want to ask you. What if that political appointee is also a very effective, a very active party man who pays his dues regularly, who attends meetings regularly, and then when the wisdom of his party leaders, they felt he was good enough to be elected a delegate to vote in the primary election.
No, let me give you my own personal experience. When I was serving as a commissioner in Osun for the 2015 National Convention, I participated as a delegate, but not in my capacity as an honorable commissioner, by somebody elected as a national delegate by the Osogbo branch of my party, APC. So I subjected myself to being elected as a national delegate. The provision of Section 8412 does not say that by mere being an appointee, you are precluded from being an elected delegate. But what it provides for is that by just being a political appointee does not qualify you as an automatic voting delegate at a convention or congress of your party. I think that is clear. I know presently today, the Honorable Commissioner for Special Duties in Osun, who incidentally is a junior brother, is an elected delegate that will participate by the grace of God at the convention on Saturday, because he was elected from our local government, Osogbo local government, as a national delegate from that local government. So he's there in his capacity as an elected delegate, not in the capacity as Honorable Commissioner for Regional Integration and Special Duties.
No.
Thank you very kindly, Senator Bashiru. We wish you a happy deliberation on Saturday when your convention takes place.
And we definitely will give our party a very successful and fruitful convention on Saturday.
We wish you well. We wish you well. We wish you well. And that's again Senator Ajibola Bashiru, spokesman of the Senate. All right then. Anything to add? Adekunle?
Oh, it's fine. Let's see what happens.
All's well that ends well.